Are human rights violations actual crimes or just moral failings? Human rights is a term that covers more than just one topic. As a subject matter, human rights is present in many academic disciplines. Interest in human rights is present in many areas of public life and is researched and taught in many disciplines. The United Nations have developed a variety of documents. These documents can cover both moral and legal boundaries. So, in this context, human rights violations can be both crimes and moral failings. Shortly after the Universal Declaration of Human Rights was drafted, the Declaration was proclaimed by the United Nations General Assembly as a common standard of achievements for all people and all nations. It includes 30 articles that define a variety of human rights. This is a very important document as it establishes moral boundaries. Every country has signed the Declaration. However, it is not legally binding. These signatures represent a moral commitment to the values represented by the Declaration. Ideally, when the Declaration was created, articles would have been integrated into member states' national laws and constitutions. This was true in some cases. However, many human rights offenses have still occurred. This becomes a sort of cyclical problem. It is government action that contributes to human rights violations, but it is also the government's responsibility to protect against them. For this reason, governments are often not held accountable for violations. When academic scholars and activists discovered this problem, they put pressure on political leaders to create multilateral treaties. Multilateral treaties are made under the control of the UN Security Council. These treaties are legal, binding documents. There are 9 main treaties and 9 optional protocol treaties. 6 of these treaties were derived directly from the Universal Declaration of Human Rights. If there is a violation of these treaties, there could be punishments, such as sanctions or military intervention. The UN does not have a military of their own, so military intervention is going to look like authorization for countries with military forces to attack another country in the name of the UN Security Council. In 2002, the Rome Statute of the International Criminal Court came into force. This treaty established the first ever criminal court focusing solely on human rights abuses. People were thrilled. It seemed like a very hopeful solution to hold countries accountable. The ICC is intended to be complementary to national criminal jurisdictions in state parties. When national jurisdictions are either unwilling or unable to try crimes, the ICC is a permanent, independent court that, in theory, has the power to do so. While the ICC seems ideal, it has failed in many ways. There have been many conflicts, armed conflicts, and wars during which documented war crimes and crimes against humanities have taken place. Yet the ICC did not take any significant action against those responsible, especially the higher-ups. When the ICC does take action, it tends to disproportionately go after African leaders. The court disproportionately took on cases that involved African countries and no cases that involved European countries, which promoted many African countries to withdraw or threaten to withdraw from the International Criminal Court.